Mr. President.
Senator from Georgia.
Thank you, Mr. President. I am always reluctant to find out that I'm following the senator from Oklahoma on the floor of the Senate. He is always prepared and always eloquent, and I want to commend the senator on his speech, but I really want to commend him on his questioning in the hearing, because he allowed us to gain and Ms. Kagan to express important points and important opinions and important judgments and important statements for everybody in this body to make up its mind. And that's what really this Senate is really all about. And it's senators like the senator from Oklahoma who help us all to do our job, and I commend him very much for his work. I also commend him for covering so many facts. My speech will be very brief. I announced about 4 weeks ago that I would not vote for the confirmation of Ms. Elena Kagan, and expressed at that time the reasons, but I wanted to memorialize that on the floor because it is a serious responsibility that we have to advise and consent on the nominations of the President of the United States. And the response to that advice and consent should always be thoughtful and should always be thorough. And mine are generally based entirely on the Constitution when it comes to the Supreme Court and in the appointments that Presidents of the United States make. Because I'm well aware that my position, the President's position, all of us in this room's position was a creation of those, our founding fathers, who wrote the Constitution that created the government that is the United States of America, and the three branches of that government that will govern us as a nation: executive, legislative, and judicial. Executive as in the President, legislative in us, and the judicial is the jury. The jury not of who's right and wrong, but is the Constitution right, is the law right that we pass in relation to the Constitution that created us. Two things in Ms. Kagan's past concerned me greatly in terms of the direction she would go as a justice on the United States Supreme Court. One's the Solomon Rule application when she was dean of the Harvard Law School. You know, we dealt, when I helped write, along with a lot of other members in this body, No Child Left Behind, we made sure that we covered this issue of military access on campuses of secondary schools and post-secondary schools. The Solomon Amendment is a simple amendment that says that if you accept federal funds as a public institution or as a private institution, in terms of Harvard through research or funds like that, that U.S. military representatives will have access to the campus. Ms. Kagan made the conscious decision of dean of the law school that that access would not be available at Harvard. And even after direction otherwise, continued in that position until she eventually withdrew. Well, Mr. President, if someone is going to the Supreme Court of the United States of America to be judge of our Constitution and its application to our legislative and judicial branch, you must remember the first responsibility designated to this Congress and to this government is to protect and defend the domestic tranquility of the people of the United States of America, and to constitute an Army and a Navy to do that. You cannot draw on that Army and Navy if you cannot draw on the people in your country. And at a time today, a contemporary time like 2010, where everyone that serves, everyone, not a one is conscripted, every single one is a volunteer. The information about the opportunities, the availability, and the promise of a career in the military or a period of service should not be denied anyone who goes to an institution that receives funds from the United States of America and from this Congress. Secondly, in Citizens United, you know, there's been a lot of talk about the Citizens United case, and there've been a lot of political arguments about the Citizens United case, but it is a First Amendment case. I don't think anybody argues about that. And in listening to the testimony in the Judiciary Committee and reading the record on the Citizens United case, it is obvious in her expression and in her arguments before the Supreme Court that Ms. Kagan felt that even though you had a First Amendment, through either printing or writing or video or audio, government could restrict political speech. Well, the First Amendment is the guarantee of free speech. And to argue a case that, notwithstanding the First Amendment, political speech could be run by the government and judged by the government, and its timing and its accessibility to me flies in the face of the very first amendment, of the first 10 amendments that finally allowed us to pass a Constitution and come together as a nation. So there are a lot of other issues. The senators that preceded me have raised a lot of those issues, and I commend Ms. Kagan, too, on her complete congeniality and her complete candor before the committee. But in terms of this senator, in terms of my vote, in terms of my judgment, it is the case and the opinions on the First Amendment in Citizens United and the actions in contrary to the Solomon Amendment and military access that to me deliver a temperament that I don't think is appropriate on a justice of the Supreme Court at this time. Mr. President, I yield back my time.